We'll begin right away. This is meeting number 82 of the Standing Committee on Access to Information. C461, and today we have with us, unfortunately we're running 25 minutes late, but we have with us from the Office of the Information Commissioner, the Information Commissioner, as well as the Assistant Commissioner, Ms. McCarthy, for Complaints Resolution and Compliance. I'll give the floor to Ms. Legault, the Information Commissioner, for approximately 10 minutes for her opening statement, and then we'll move on to questions from members. You have the floor, Commissioner. Thank you very much, Mr. Chairman. Let me begin by thanking you for inviting me to speak to you today in relation to your study of Bill C461.
Repeal of Section 68.1 of the Access to Information Act, which excludes information relating to the Canadian Broadcasting Corporation's journalistic, creative or programming activities, subject to an exception for information relating to its general administration. The bill would replace that exclusion with a new exemption which will allow CBC to withhold records which could reasonably be expected to prejudice the journalistic, creative or programming independence of the CBC. D'abord, permettez-moi de vous expliquer brièvement.
At the outset, I would like to describe briefly the general structure of the Act, the limits to the right of access, and the powers given to my office. And, Mr. Chairman, I did hand out a committee for the members that provides you with greater detail on exemptions and exclusions and the difference between the two, and also a general description of those provisions in the bills in question. The Access to Information Act creates a right to access information under the control of government institutions subject to specific and limited exceptions. The Act limits access by way of exemptions and exclusions.
Provide that the Act does not apply to certain record or information. The Act also includes various exemptions which permit or require institutions to withhold a range of records and information. The Act gives the Commissioner broad investigatory powers, including access to all the documents under the control of a federal institution to which the Act applies. The Commissioner has a broad power to require the production of these records. Thus, when an exemption is invoked by an institution, the Commissioner has access to the documents in their entirety. However, where an institution invokes an exclusion, access to the underlying information or records depends on the nature of the exclusion relied on by the institution. The Commissioner's access to records and information which had been identified by the CBC as falling within the exclusion found in Section 68.1 was at issue before the Federal Court of Appeal at the time of my appearance in October 2011. In November 2011, the Federal Court of Appeal rendered its decision. Cette question de la portée des pouvoirs.
The extent of the Commissioner's power to review records over which CBC had applied the exclusion in Section 68.1 arose in the context of a number of investigations into complaints about the application of the exclusion by the CBC. CBC challenged the Commissioner's power to compel the production of documents that it claimed were excluded by Section 68.1 of the Act. On appeal, the Court of Appeal confirmed that the Commissioner is allowed access to the records. With respect to information about a journalistic source, the Federal Court of Appeal observed the identity of journalistic sources cannot clash with the exception relating to general administration, regardless of the scope attributed to this exception. In these circumstances, the only conclusion possible, if one gives effect to the federal court judge's reasoning, is that the exclusion for journalistic sources, like the exclusions provided in Sections 69 and 69.1, is absolute. It follows that in the event that a request seeking the disclosure of journalistic sources was made, a record or the part thereof revealing this type of information would be exempt from the Commissioner's power of examination. In its decision, the Court of Appeal resolved the scope of the Commissioner's power to compel the production of the records to which CBC has applied Section 68.1. What the decision does not resolve is the scope of the exception to the exclusion and the meaning of terms used in Section 68.1, such as the journalistic, creative, or programming activities. Subsequent litigation on these issues cannot, therefore, be excluded.
Discuss the specific modifications proposed by Bill C-461, I think it is important to emphasize that the challenges related to access to information are complex. They demand thoughtful, unified action and are not amenable easily to a piecemeal solution. Like my predecessors, I have more than once observed that the Act requires modernization to bring it in line with more progressive national and international models. While it is true that the Act was considered state-of-the-art legislation when it received royal assent in 1982, it is now significantly outdated. While acknowledging the need to amend the law, I maintain that it should not be done in a disjointed way, since this leads to issue-specific amendments which erode the Act's status as a law of general application. At the very least, the structure of the Act as a whole must be considered when amendments are proposed. We must examine not only the specific interests to be protected by changes or additions to the law, but also the spirit of the law, the way in which it is structured, and its general framework. The chosen approach must, in my view, preserve the law's character as one of general application. The amendments proposed in Bill C-461 in relation to the CBC reflect what I suggested when I appeared before this committee in October 2011. Since the committee has been having hearings, I have been following very closely the comments of the stakeholders as well as the comments of parliamentarians in the House of Commons, and I'll be happy to discuss some of the issues that have been raised by various parties. At this time, Bill C-461 proposes to repeal the Section 68.1 and the insertion of a discretionary injury-based exemption that would permit the CBC to withhold information that could reasonably be expected to prejudice the corporation's journalistic, creative, or programming independence. A discretionary injury-based exemption will ensure requesters' rights to an independent review process in all matters. To be clear, any information or records obtained by my office are reviewed solely for investigative purposes. Indeed, the Access Act's confidentiality requirements are very strict and do not allow the disclosure of any information during the performance of my duties or functions. Finalement,
in concluding, I ask the committee to consider how these proposed amendments to the Act will apply to the more than 200 complaints currently under investigation. Will it be applicable to ongoing files, requests to the CBC and complaints, to my office, or only to new requests? The bill, as it stands, does not refer to any transitional measures to deal with ongoing files, so I would ask the committee to consider that in their deliberations. In my view, it would be better that the new provisions be applicable to existing complaints and requests, since a requester may simply make a new request, thereby benefiting from the application of the new provisions. Now, for that to work, there has to be a specific provision. On that, Mr. Chairman, I would be pleased to answer your questions. Thank you very much for your opening statement. And Mr. Nantel, you have Mr. Boulris, you have the floor for 7 minutes. Thank you very much, Mr. Chairman, and thank you, Commissioner, for coming today. I think there are several related issues here, and it's a complex area. It's also a very important area for the purposes of the public interest and transparency, and also for the purposes of the ability of the CBC to undertake their work. Could you tell us how you interpret the term independence that is used in the bill? Because protection is provided to CBC on the journalistic, creative, and programming work that they do. But this exemption only applies if it affects the independence of that. Are we talking about the arm's length or independence of the CBC with respect to the government, or something else? That's a good question. And several witnesses, I am aware, raised that concern. I'll tell you what I was looking at when I proposed this in 2011. It really is in the guidelines for CBC themselves. On page 5 in these guidelines. Now, I'm sorry, I only have the English version with me, so if I may, I'd like to read it. On page 5, I do apologize. On page 5, it says, well, perhaps I'll just translate it as I go and you can consult it. So 68.1 of the Act was drafted with a great amount of flexibility in mind because it applies to all information under the CBC which is linked to the journalistic programming. So relates to are the words that are used in English. So that can be interpreted broadly. And then on page 5, it says that interpreting the exclusion can be very broad. So it says that there has to be a broad interpretation of what that means. After then, on page 6 in these guidelines,
to interpret the language that way, given the legislator's objectives as regards access to information and the corporation's desire to be transparent and accountable. CBC therefore based itself on the principles underlying subsection 52(2) of the Broadcasting Act, along with the general philosophy it proffers with respect to the importance of striking a balance between accountability and transparency on the one hand and the public broadcaster's independence on the other. Therefore, when the corporation is faced with an access to information request for information subject to CBC's exclusion, it can disclose it as long as doing so allows it to maintain its journalistic, creative, and programming independence. That's where it comes from. Now, I have listened to what's been said, and I've also spoken to a couple of journalists that are now in the academic field since the bill has been tabled. Chris Waddell and Jeff Sallet, who are both at Carleton University, who are used to working with sources. And so I've spoken to these folks, and we've looked at the Broadcasting Act as well. And what you see in the Broadcasting Act is that there are various provisions that talk about freedom of expression and journalistic, creative, and programming independence. 52(2) is more specific because it relates to the financial reporting obligations of the CBC towards the government.
Mais par exemple, si,
However, if CBC, let's say, is preparing a report on, say, a new controversial drug, and the pharmaceutical company is aware that that report is being made, and then they make an access to information request to find out what they're doing, will this affect their independence? Do you think, in other words, the pharmaceutical company would be able to get that information and actually end up disrupting or preventing that report? Well, I cannot use hypothetical examples. However, what I would say is that With the discretionary injury-based exemption, I would say as it is drafted now, it has never been interpreted within the Access to Information Act in that way. What we have is the Broadcasting Act, and under some provisions there is a reference to freedom of expression as well as independence. Now, can that give you an indication of what you need to do? Perhaps the words freedom of expression could be added to journalistic, creative, or programming independence. Maybe that would provide some extra comfort level for with respect to the concerns that were raised. I have another question with respect to journalistic sources. You said that you need to have access to sources because you're used to dealing with sensitive documents so that you can have access to that. Now, it's all very well to trust you. I know we can trust you. But that's not what we're challenging or questioning here. Our question is that link of trust, the trust between the source and the journalist. There may be information that is going to be given to a journalist, but maybe that third party won't provide that information if they know that someone else, a third party, is going to have access, such as yourself. Reporters feel that the protection of sources is fundamental. Some reporters even go to prison in order to protect that confidential nature of their source. So regardless of who has access, it can end up undermining that trust. Yes, I've listened to those concerns. Now, I will admit that as Information Commissioner, I am absolutely against exclusions under the Access to Information Act. I've experienced this with cabinet documents, for example, that are excluded. And even though I can't see the documents, there have been investigations that have shown that those exclusions were well-founded for cabinet documents. Now, I'm sorry, I only have a few seconds, and I have two motions to table, Mr. Chairman. I would like to be able to table those. I only had 7 minutes. I really would love to continue with you, but I would like to table two motions. I am presenting one first to allow for hearing the Privacy Commissioner at another meeting of the committee, and I also have a second motion that I would like to table, but perhaps we could deal with the first motion first. Is there consent to invite the Privacy Commissioner for an extra meeting before the committee? Yes, in that case we will do whatever is necessary to have our 5 meetings. My next motion is similar. I would like to add another meeting so that the committee use one extra meeting for the consideration of C-461 in order to invite back the sponsor of the bill, Mr. Brent Rathgeber, to appear before the committee before we begin clause-by-clause study. Is there any debate? Mr. Andrews?
Beginning when Mr. Rathgeber came, that we wanted to ensure that we had full fairness and due diligence for private members. Business is important, and for a backbench member or any member to bring forward their legislation, they have the right to come to committee and be heard. Unfortunately, Mr. Rathgeber didn't get the full chance to be heard because we were interrupted. We had one round, but normally we would have given him the full period. And I just feel that it's a fundamental issue of respect, whether or not we always support the bill or not. This is part of our job as parliamentarians, and I'd like to give Mr. Rathgeber the chance to have the full chance to go around and hear from the MPs. And we'd prefer not to spend too long on the debate. We'd like to be able to move on because I know my colleagues wanted to certainly talk with the Commissioner, but we're running out of time on this, so if we had the indulgence of the committee, we could pass that and then move on.
So, la motion, Mr. Workind.
We don't oppose that. We just oppose this practice of eating into witnesses' time in order to undertake committee business. So in the future, I'd like to maybe defer this until committee business, but we have no opposition to hearing Mr. Rathgeber.
Donc, tous ceux qui sont en faveur de la motion.
All those in favor of the motion, please raise your hand. All those opposed? Anyone abstaining? In that case, we will add another meeting. Monday the 3rd, I believe, the 3rd of June. And we will ask those extra witnesses to come back. So that will be the 5th meeting. So this study then will last 5 meetings as opposed to 4. That will change our dates somewhat. For the tabling of any amendments, that will be now put off until Tuesday, 9 o'clock, the 4th of June. And I'll now give the floor to Ms. Davidson for questions to the witnesses.
Chair. And thanks very much, Commissioner and Ms. McCarthy, for being with us today. And, I want to go back to the exclusions and exemptions because I find it very confusing. And so I'd like you to talk to us again about how this distinction is important in the context of the bill. And I know that you said in your remarks that you were against one of them, exclusions, and then you went on to talk a bit about when an exemption is invoked. So could you please talk to us about that? And then if you have time at the end, I was interested in what you said about the considering how the proposed amendments will apply to the current backlog that we've got, or the current numbers that we've got. So perhaps you could talk a bit more about that if you have time. Thank you.
Okay. The most significant distinction really with the exemption that we have before us in C461. I'll just speak in terms of the specific exemption and exclusion. That way it'll be, I think, clearer. So the current exemption that's being proposed is a discretionary exemption, and there's a prejudice test, and it's linked to the independence. So there is an exercise of discretion that has to be done by the head of the institution. So if there's an access to information request, the institution will have to determine whether the records that have been asked for fall within the category of records, whether they apply to journalistic, creative, or programming. They're those kinds of records. And if they are, then they have the discretion to disclose them or not, looking at whether or not it will prejudice their independence. That's essentially the exercise they're going to have to do. And Emily can correct me. She's dealing with these all the time. If it's an exclusion, basically what the CBC is currently doing is basically saying, okay, it's asking themselves whether the records relate to anything that has to do with programming, creative, or journalistic activities. And if it does, then they have to determine whether it's, however, related to general administration. You can imagine that for a public broadcaster, most of its records relate to programming, creative, and journalistic activities. The difficulty with the files in relation to the CBC is because the general administration part is sort of intertwined with in the records. So whether we have an exemption or whether we have an exclusion, that difficulty in terms of deciding what can be disclosed or not will always remain. C461 will not resolve the difficulty in finding out what the exemption applies to or what the exclusion applies to.
Will it confuse the issue more, or will it do anything to the issue?
It's different because what it does is it allows the head of the institution essentially to apply its guidelines and to basically say, well, yes, in this case, it is something that applies to our programming activity, or it's something that is a record related to programming. However, in this particular instance, disclosure would not prejudice my independence. That's what it allows the head of the institution to do. So from my perspective, I would think that it should generate more disclosure.
Okay. And then the issue with the 200 or so backlog or existing.
That's a matter of transition between a new provision and an old provision, and the fact that we already have cases. And perhaps, Emily, you can talk about transition provisions. And
it would just clarify the application of the statute. If you have a transitional provision, then it would be clear to all involved which law would be applicable, whether the ongoing cases would be governed by the new provision, or whether we would continue to investigate based on the previous provision. But as the Commissioner mentioned earlier, that raises a difficulty in the sense that the requester could then make a new request for the same information based under the new provision. And so you can see where there would be potentially a difficulty where we would be required to make a finding under the existing language as it is right now, but also have a complaint relating to the new provision. It'd be in a sense, a use of resources that might not be entirely productive.
So your office then would think that it would be better to have it apply to everything that you have on file now?
I think so, and my understanding of transition legislation or transition law is that, and you really have to speak to experts on that, my understanding is that if we don't provide something specific in the legislation, in the private members bill, that we would be faced with the situation that the Assistant Commissioner is describing, i.e. I would have a set of complaints where the old law would apply and new complaints where the new law would apply. And my difficulty with that is I think that that would not be very good for taxpayers to have me spend time and my office staff investigate old complaints under old legislation. And if I have a disagreement and the CBC is not in agreement with my recommendations for a disclosure, then it's certainly not a case I would like to take to court, because that would be a waste of taxpayers' money. And so I think we need to provide for transition provisions so that this does not occur.
Okay, thank you. I'm out of time.
Time is up. I will now move on to Mr. Andrews for 7 minutes.
Folks, got a question regarding the government is going to propose an amendment to Mr. Rathgaber's bill on two fronts, and I'd like to get your opinion. They're going to come with an amendment regarding journalistic sources amendment. How should that amendment look? If they want to protect journalistic sources, what kind of amendment could we make to this bill to protect journalistic sources?
Well, first, I must say that in my view, journalistic sources will be protected anyway. I think they're protected under the current Act, and I think they will be protected under the proposed bill as well. And then you have to look at the Act as a whole. Section 19 of the Act protects personal information as well, and which is also a provision we use in matters of human sources, for instance, in national security matters. So as far as I'm concerned, the fact that it's a discretionary exemption would still protect journalistic sources, because the fact that I am allowed to review documents does not mean that they will be disclosed. It doesn't address your colleague's point. In terms of an amendment, you know, I must seriously admit that the idea of having now a new amendment that would make an exclusion to a discretionary exemption, and I have not seen it, having spent several years in litigation to try to assess how an exception to an exclusion applies, is a little bit of seriously, operationally, I would rather not see that, and I would certainly prefer to see a proposed amendment before that's being done, especially since I actually think it's not necessary to protect journalistic sources.
How do you square that with the testimony we heard last committee meeting, where every witness had said that this is their biggest concern?
Yeah, I frankly don't see it, because there's two issues. One is the fact that I have the right to review documents which could include journalistic sources. That's the first issue. In my view, because of the confidentiality provisions, does not mean that the journalistic sources are compromised. Secondly, there does not exist at this time a full-fledged protection of journalistic sources anyway, which goes to the point of your colleague when people say, well, if there's a potential it can be disclosed. Well, there is actually a potential now that journalistic sources be disclosed because they can be disclosed by a court under the Wigmore test. So it's not an absolute privilege. It's not an absolute protection. And so that is the status quo right now. So I'm not going to comment on an amendment I haven't seen, but please consider this. You are going to create another difficult situation if we create another exclusion to an exemption. How that's going to work, I really don't know, and I haven't seen any amendments. I really don't know how that would work in practice. If it's going to happen, my recommendation would be to have a mandatory exemption and not an exclusion, which would mean that it would be mandatory for the CBC to protect journalistic sources. But that would still allow me to review the matters. And I'll tell you why I think it's best if I'm allowed to review the matters. You can, and we have this in matters of national security all the time in terms of human sources. You can have a whole document, and there are human sources that are being referred to in the document. And then there are other types of information that may allow you to identify the human source. And then there's other peripheral information which the institution could claim that it's allowing to identify the journalistic source. It's not so simple. So far, we have not had any case that dealt with journalistic sources. So it is not a big issue. Is it worth complicating the act and adding an exclusion to an exemption? My advice is no.
Okay. How am I doing on time, guys? Okay. Well, I'm going to throw my last three questions into you, into the one. The injury-based exemption that is being proposed in this bill, how will it work, and will it work well? Is it something that we should be looking at? Because I think the injury exemption is something that we haven't really dealt with in any pieces of our legislation, if I'm not mistaken. And my second question: often we hear when we card CBC that one of their competitors is going to get information about them. Explain to us how, under the business model, as I understand it, or as business right now, if something relates to a business thing, part of the business, it can't be released anyways because it's under competitive. So can you just answer or enlighten us on those three things, please? Yeah. Thank you.
There are other provisions in the Access to Information Act that protect information. Obviously, there's protection for commercially sensitive information, for instance. There's protection for personal information, which a source would be. It would protect its own personal information. It's a mandatory exemption. In terms of other discretionary injury-based exemptions in the Act, there are others. C'est ça, l'article 15, section 15, which deals with national security. It probably deals with some of the most sensitive information that we review under the legislation, and that's an exemption that is discretionary and that is subject to an injury test. And that has been in existence for 30 years, and that has worked extremely well. And so far as I know, there has not been any leak of security, highly sensitive security information from my office. What we do in those cases, though, and that is something that I'm perfectly prepared to do in our investigations with the CBC, is that we go on site to consult the most sensitive information, so that we don't take the documents at our office. We basically go in and we look at the documents ourselves just to assure ourselves that it is actually information that deserves protection. We could very easily do the same thing with journalistic sources if the CBC felt more comfortable that we would basically go there and not take the documents out and just satisfy ourselves that the exemption is properly applied. So no, it's not novel in the Act, that kind of exemption. It exists, it has functioned very well. Institutions function very well, and in fact I would say if you look at the guidelines of the CBC, that's really what they're proposing to do. Our experience so far with the CBC investigations, that it's essentially what we are seeing in the application of the specific complaints. So the CBC is maximizing disclosure as through our investigations right now, applying a similar exemption even though they're actually covered by an exclusion.
Merci, le temps est écoulé. Donc,
Thank you. Your time is up. Mr. Mays, you now have 7 minutes.
First of all, I want to say I have all confidence in your judgment when you're looking at these files and the sensitivity of it and understanding some of the implications. We had CBC here last meeting, and they made a statement in their presentation, their submission, that you gave them an A for their openness to access to information. But I've since found out that, and I would just want you to confirm this, that you gave them an A for timeliness, but you still gave them a D for the access to information, for the scope of the information. Now, is that correct or not correct?
No. The report cards only deal with the timeliness issues. We do our report cards fairly regularly. That was the last of a 3-year cycle. We reviewed CBC twice. The first year we reviewed them, they got an F in terms of timeliness. The last year we reviewed them, which was last year, they did very, very well in terms of timeliness. They have very few complaints related to timeliness, and we work extremely closely with the CBC in trying to resolve the cases. I mean, the Assistant Commissioner can speak to that. We are intensely working with the CBC to resolve these cases, and there has been significant additional disclosure. There were growing pains, definitely, at the beginning of this legislation. But now, and I have spoken to Monsieur Lacroix, I have his full collaboration, and our offices are working very well on the complaints resolution. We have not, so far, really had to resolve a case on the basis of 68.1. We have resolved them with the use of other provisions of the Act.
Well, that's good to hear. And when I talked to the CBC representatives, that's what I said. You know, actually, this has been good for them because it's made them more aware of their how they have to be open, but they also are more sensitive to what you're doing. And I think we've made some gains, as you've said, and I think that's very positive. In your opening statement, you said that we need to look at the national and international models as far as our guidelines, and that ours might be outdated. And I'm just wondering, with regards to that, and specifically around 68.1, what do you find in places like United Kingdom and other countries as far as those type of exemptions, because I'm sure they have them? And how do we match up with you know, this current bill that we have and the existing 68.1?
Yeah. Thank you. When I appeared in 2011 and I recommended the discretionary exemption, I did say, if I recall correctly, that I really was an outlier internationally, and that's why at that time I had provided the committee with the international models. Because in other jurisdictions, like the UK and Australia, for instance, which are good comparatives, their national broadcasters are covered by the Access to Information Act. However, most of the information is excluded or derogated. They use different terms. It's difficult to compare. They're essentially excluded in terms of their programming activities and journalistic activities. The difference is that their sort of exclusion or derogation kind of work like our exemption in the sense that their commissioners are entitled to review the records, including, as far as I can tell, journalistic sources. We did contact the UK and the Australians following some of the debates in the House of Commons, because I was alerted to this concern in terms of whether or not this would affect the competitiveness of the public broadcaster, if there was a distinction in terms of being covered by the Act and its journalistic sources covered by the Act and other broadcasters. None of the two jurisdictions has indicated that that has been an issue at all in the UK or Australia. So that's the extent of what I know.
So is there, anything in this bill at, under section 18.2 that you can see that maybe could be amended? Any suggestions that you would have that would make your life simpler?
Well, the only thing that I think the committee should consider seriously, given everything that we've heard, and what I've heard is that there's two things I've heard. One is a concern that the fact that we're talking about journalistic, creative, or programming independence, there is a concern that this is not sufficient to protect freedom of expression, editorial freedom, or journalistic integrity. That's what I've heard, and that's what I've been told also by other stakeholders. When I looked back at the Broadcasting Act with Emily and her group, we found that in the Broadcasting Act there are various provisions that deal with broadcasters generally and the CBC, and they do speak about freedom of expression and journalistic, creative, or programming independence. They use all of that, generally speaking. So perhaps the committee could consider having 18.2 amended so that it would read at the end, could reasonably be expected to prejudice the corporation's freedom of expression and journalistic, creative, or programming independence. Now that would truly mirror the Broadcasting Act in its other provisions. It could alleviate some of the stakeholders' concerns. The other option would be to leave it as is, and instead of independence, to use the word that we have in the current 68.1, which is activities. So it would read the corporation's journalistic, creative, or programming activities. And that's much broader than just the concept of independence, I think. Although we don't know at this point how we would interpret it. And that concept has not really been interpreted under 68.1 either. But those are two options, I think, that might go some way to alleviate some of the concerns of the stakeholder in relation to the freedom of expression and editorial freedom. In terms of journalistic sources, as I've said, I really personally do not think there is an issue with a discretionary exemption in relation to the protection of journalistic sources, nor have I really found any evidence that this would affect the competitive position of the CBC.
Thank you.
Merci. Le temps est écoulé.
Thank you. That ends the first part of our meeting. Ms. Legault, unfortunately, we are 30 minutes behind, so we decided to give 45 minutes to each witness because there are other witnesses here. I'd like to thank you again for coming. Mr. Chairman, point of order. It's about the Information Commissioner's testimony. The official opposition only had one 7-minute opportunity to ask question, and the government had two. I would request another 5 minutes, please, so that at least we have an opportunity to ask 2 questions. Well, we used the first round for our first part of our meeting. And it was in June 2011 we decided that the first round was 7 minutes, once for the NDP, twice for the Conservatives, and once for the Liberals. That is what the committee passed, and out of fairness, we have to provide 45 minutes to both witnesses. And so that's why I have decided, well, out of fairness, then, could the official opposition also have 2 opportunities to put questions, because the government had an opportunity to put 2 questions? No, but the committee did decide this. There are more. They're on the government side. They have the majority, so they also have an opportunity to ask more questions. You can decide something else if you like, Mr. Chairman. Well, yes, I can ask for unanimous consent and give less time to the following witnesses. Do I have the consent to do that? I'm afraid I don't have consent. And so I'm going to thank Ms. Legault for coming, and I'll suspend for a few minutes to provide time to the next witnesses to come forward. Thank you.
Donc, je rappelle le comité à l'ordre.
Order, please. We'll now continue our meeting on Bill C-461. We have two new witnesses with us. First, Mr. Gregory Thomas, the Federal Director of the Canadian Taxpayers Federation, and Mr. Taylor, the Director of the National Citizens Coalition. Mr. Thomas, you will come first for your opening statement for 10 minutes, and then Mr. Taylor, you also have 10 minutes for your opening statement, and as we did earlier on, there will be 7-minute questions until the end of the meeting. Thank you very much, and Mr. Thomas, you have the floor.
I'd like to thank you all for allowing me to join you today. I'd also like to thank Brent Rathgeber for proposing Bill C-461. In support of this bill, Mr. Rathgeber has shown character and courage in standing up for his beliefs and to his caucus when he has nothing to gain politically or personally by supporting this bill. This is evidence that principles are still alive and well in the House of Commons, and this gives us at the Canadian Taxpayers Federation hope that this bill will lead the government in the right direction. My name is Gregory Thomas. I'm the Federal Director of the Canadian Taxpayers Federation. We are a federally incorporated, not-for-profit citizens group dedicated to lower taxes, less waste, and accountable government, and represent over 84,000 supporters across Canada. I'm here on behalf of our Taxpayers Federation and our supporters to defend the current iteration of Mr. Rathgeber's bill. We believe that all governments should stick to their founding tenets, transparency and accountability to the people. When administrations base their governments on these two seemingly simple ideas, it benefits themselves, their supporters, and everyone in between. More accountability to the public gives taxpayers the rights they deserve to know who is being paid with their tax dollars and how much of our money they receive. Bill C-461 would cause the government to disclose all earnings above $188,000. And we believe this is a necessary shift in federal disclosure policy. Although in a perfect world, every penny paid out by the government would be public information, we believe Mr. Rathgeber's bill pushes the government away from its self-imposed opaqueness and pushes the government into disclosure policy that will greatly benefit all Canadians. This bill in its current state, we feel, does not go far enough. But the enthusiasm and hard work put in by Mr. Rathgeber makes up for this and gives us hope that other MPs will push for further reforms in the future. That being said, there have been criticisms of these amendments from all sides of the House, and I would like to address each of them. First, there's concern regarding the amount of people who would land above the $188,000 salary disclosure limit. Their concerns have centered on the amount of people whose salaries would be disclosed. We believe this is a non-issue in this discussion. Government employees are all accountable to the public precisely because we sustain their salaries. To suggest otherwise takes away from the real issues affecting Canadians: government accountability and transparency. We hear this from the government, and quite frankly, it confuses us. I'm not the first one, nor will I be the last to reference the current Senate expenses scandal involving former Conservatives Mike Duffy and Pamela Wallin, Patrick Brazeau, and former Liberal Senator Mac Harb. If the government allowed us access to the records and documents relating to their expense claims, this wasteful, unaccountable spending could have been nipped in the bud before it spiraled out of control into a $90,000 check and many reputations being tarnished. The same will go for this bill. If we see what government employees are earning, we can stop unreasonable salaries, benefits, and pension entitlements before they spiral out of control. It should be clear that this would help any government avoid embarrassment and scandal while ensuring taxpayers are being treated with the respect they deserve. The other major criticism relates to the effects of this bill on the Canadian Broadcasting Corporation. Again, we believe this takes away from the real issues surrounding the amendments. The CBC is not the only affected Crown Corporation. All Crown agencies, from the Atlantic Pilotage Authority to Via Rail, are covered in this bill. In fact, there's a specific provision in this bill that would allow the CBC to withhold information that threatens its independence, and it would be subject to a test that could be tried in the courts. We believe that there are plenty of members in the official opposition, as well as the Liberal Party, who genuinely support the spirit of this legislation, and I'd simply plead with you not to get caught up in the sideshow that relates to the CBC, but to rather focus on the real issue, which is accountability, transparency, and waste. Now, you may be asking yourself, how exactly does federal disclosure policy help the average taxpayer, the average citizens? The fact of the matter is this: if we can see what Crown CEOs are making and what their job descriptions are, we can avoid potential scandals before they spiral out of control. Now, you may believe that not every Canadian pays attention to the salaries of government officials. It's a valid assumption, and I don't deny it. However, we still owe it to taxpayers to treat their dollars with dignity, and even if every Canadian on every main street in Canada isn't going to file an access to information request, you can be assured that the Taxpayers Federation, as well as other advocacy groups, a free press, a free media, will be watching vigilantly to see how taxpayers' dollars are spent. We're here to ensure that government operates within reasonable limits, and the day we stop respecting a person's money because they don't have the time or resources to be involved in the same manner as you are is the day I believe we lose our moral authority to levy taxes. I hope my testimony has shed some light on this issue. Canadians deserve the best from their government, and we believe the public's concerns until this bill have arrived have been falling on deaf ears. Again, we commend Mr. Rathgeber and all members who support this legislation. You are the people who listen to Canadians and who are working for positive change in the stewardship the government shows over our tax dollars. Thank you very much.
Merci pour votre présentation. Donc, tout de suite, je passe la parole.
Thank you for your statement, and we'll now move on to Mr. Taylor, the Director of the National Citizens Coalition.
The National Citizens Coalition is a supporter-based organization founded in 1967 and counts tens of thousands of supporters in its ranks. Our organization is founded upon the principle of more freedom through less government. We advocate on issues regarding the reduction of waste in the public sector for the more efficient delivery of services to Canadians. Government accountability is very important to our supporters and indeed to all Canadians. Whenever taxpayers' dollars are in the mix, we believe on a philosophical level that Canadians deserve transparency for where those tax dollars go and accountability by those who spend them. Recent scandals in the Canadian Senate with regard to how our senators are spending their housing allowances serves to underscore the need for transparency and accountability in our public institutions. Canadians lose faith in their institutions when those institutions abuse the public trust. Since human fallibility seems to be fairly consistent, the system must account for it, and accountability measures must be built in. We are here to provide testimony in support of Bill C-461. The CBC and Public Service Disclosure and Transparency Act is an important piece of legislation to bring transparency and accountability to the spending of public dollars at the Canadian Broadcasting Corporation. The CBC is the recipient of over $1 billion taxpayer dollars every year. Section 68.1 of the Access to Information Act is deficient, in our view, because the CBC has used it as a blanket exclusion for allowing the oversight of how it spends public money. The Information Commissioner, the Federal Court, and the Federal Court of Appeal all agree to the limitations of Section 68.1 as written. Further to the changes to the Access to Information Act, the legislation also makes other important changes to current statute. Canadians have been well served by the so-called sunshine lists in provincial jurisdictions, which list salaries and expenses of public servants. Unfortunately, such a list does not exist federally, and this legislation does not go far enough, in our view, in establishing such a list. Mr. Rathgaber's middle measure is to provide specific salary figures and expenses on individual federal payroll, however, upon request. Also troubling is the proposed amendment by this government to raise the threshold for the reporting level. In Ontario, for example, we benefit from disclosure of salaries $100,000 and above. Mr. Rathgaber suggests a federal list should require disclosure at or above DM1. We implore the members of this committee to resist pressure to raise the threshold from Mr. Rathgaber's proposed figure. Ideally, though, we'd like to see the disclosure set around $100,000. Perhaps wishful thinking. Also less than ideal is the per-request mechanism. We hope the committee will see the benefit of full and automatic disclosure of salaries, expenses, and bonuses on a public website in a machine-readable format. The world is moving to the open data model of governance. I note that Canada has fallen to 55th place in the world for freedom of information. Canada is watching what legislators do in this place. As scandal looms regarding the abuse of taxpayers' dollars, some have suggested the abolition of the Senate. Transparency provides an automatic mechanism that helps protect against those who would abuse the public's trust. Such transparency does not exist at the CBC. The National Citizens Coalition view is the privatization of the CBC. This isn't a big secret. I know that this view is not yet shared publicly by many in this room. However, if the CBC is to receive public dollars, it suffers a legitimacy gap when it refuses to disclose how those dollars are spent. For those that do believe in a public broadcaster, you bring legitimacy to it as a public institution when it is accountable to the public for how it spends our money. Regarding the CBC-related amendment to this legislation, that is to include an exclusion for journalistic source protection while allowing for an injury test exemption on programming-related information disclosure. You know, this sounds acceptable in principle. However, the CBC has acted in bad faith on previous access to information requests claiming blanket exclusion under 68.1 of the Privacy Act. The Information Commissioner has taken the CBC to court at least twice on this matter. We are concerned that the CBC will use any loophole to protect against reasonable disclosure. We believe that the voting public is the best judge for how its money is spent. We do believe in less government. Many of you do believe in more of it. However, shrouding this information from the public view is not an honest mechanism for protecting government largesse. Indeed, it delegitimizes the view that advocates for it in the absence of such disclosure. Government members may be looking to amend this legislation to raise the reporting thresholds and ranges for disclosure with respect to public sector salaries and bonuses. This will put more data out of reach from the public on how public dollars are spent on public services. I'm told that this legislation will pass with such an amendment. Indeed, this bill faces a fork in the road. If this legislation fails because it lacks this particular amendment, it will be scandalous for the majority governing caucus. This is legislation that calls to the very heart of the Conservative base. Such transparency is a core theme of why Conservatives elect Conservative Party candidates to serve in Ottawa. If this legislation is amended to raise the disclosure limit and passes, it will be a watered-down, paler version of itself. I implore the government members to resist amending the disclosure threshold because recent troubles facing this government on accountability issues provides the impetus for passing the legislation that we small C Conservatives desire. And with that, I welcome your questions on this presentation.
Merci beaucoup à vous deux pour...
Thank you to you both for your opening statements. And we'll now start with Mr. Boulris, who will be sharing his time with Mr. Nantel. Thank you very much, Mr. Chairman. I listened to you both closely. The current bill focuses on CBC. However, it does only apply to that institution in Annex 1 in the Access to Information Act, but it does not focus on the PMO's office. So I'd like to ask you a question. You are making a plea in favor of transparency. So if we want to know what Peter Mansbridge earns every year, shouldn't we also be able to know how much Nigel Wright or any other chief of staff earns?
Legislation that threshold would be $100,000. We don't believe that Parliament should be exempt. We don't believe that political staff should be exempt, and we believe that it should be a straight $100,000 threshold for all federal government employees.
Okay, merci.
I'd like to echo my colleague's statement. If anyone earns over $100,000 taxpayer dollars through this government by their salary, whether chief of staff or any other public servant, that should be accessible on a publicly disclosed on a website. And I'd ask that if members here do believe in such transparency for members of the Prime Minister's office or political members of this government, in the sake of transparency and disclosure, they should also agree with such measures of disclosure and transparency for every such dollar in every Crown corporation as well.
Merci beaucoup. Au moins, ça a l'avantage d'être clair. Ça règle ça.
Thank you very much. We often hear this. CBC is $1.1 billion per year in taxpayers' money. So I'd just like to put some perspective on this and hear what you have to say. Public funds are a small part of the CBC's budget. CBC has to sell its, has to have advertising, has to sell its programming. So less than 50% is public funds. Now there are other OECD countries that, for the majority, have public broadcasters. In Germany, for each citizen, that costs $147 per year. In Japan, it's about $90 per citizen. And in the United Kingdom, it's about $90 as well. In Canada, CBC costs about $34 per citizen a year. And that's all. So it's about a third of the cost in the UK or in Japan. So I think we're getting something that's pretty good for our money. We're getting our money's worth. And it provides diversity of programming, TV shows on Canada, in many regions of Canada. And we're getting that at a pretty discounted price if you compare that to other countries.
I mean, it's no secret that the National Citizens Coalition does stand for privatization of the Canadian Broadcasting Corporation. We think that if people think that the CBC is such a great deal, they can put their own dollars into it. In the age of the internet and the YouTube generation, you know, I heard a statistic from Google the other day that more Canadian content has been consumed by Canadians on YouTube since 2010 than has been consumed since on CTV and CBC since the 1950s. So, like the accessibility of Canadian content, especially by Canadians themselves being able to tell their own stories without the need for a public broadcaster, you know, I'd welcome that discussion as well, but I do believe that might be out of scope of this particular bill.
Pour la Fédération canadienne des...
But my colleague, Mr. Nantel, would like to put a question. The Canadian Taxpayers Federation has a similar approach. He called on the other conservatives to support this bill, but within our organization, we're not necessarily a conservative organization. We have no ties, political ties. And in terms of CBC and other organizations, we are against any grants, any other broadcaster, for whether it be Rogers, anyone else, public or private. Our position is not all that different from Mr. Taylor's position. Well, thank you, and quite honestly, thank you very much. We wouldn't necessarily agree, but I am very interested in what you have to say. And this is a good time then to put a question to you. Mr. Thomas, what do you think about Scrap the CBC campaign? We undertake polls and surveys amongst the supporters of our organization. When there's a subject, an issue, for example, let's say marijuana legislation or Senate-related issues, there are those in the West who would like to have an elected Senate, others who would like to abolish the Senate. So there are those in our organization who want to keep CBC, and we have supporters in various communities in the West and in the Maritimes. And I'd just like to interrupt you. I have a question for you. Would you not prefer that the Information Commissioner have just more authority for the production of documents? Would you have liked that power to be provided to the Commissioner, that she compel production of documents?
Interest here is to c'est pour plus de transparency quant au salaire au gouvernement fédéral.
The question related to CBC is not the central issue as such. We have the access to information legislation. This is a very specialized area. Mr. Rathgeber is a lawyer. He's very well educated in all those aspects. And his opinion is that the existing legislation is not specific enough, at least not to necessarily get the job done.
We have not thoroughly examined this, but Mr. Rathgeber's point is that an exemption is a bad way to address the issue of the independence of the CBC. He believes that an injury test will give the courts and the Information Commissioner a better tool to protect the independence of the CBC while ensuring that the CBC complies with access to information requirements.
Merci pour vos réponses.
Thank you very much. Ms. Davidson, you now have the floor for 7 minutes.
Thank you, gentlemen, both of you, for being here with us and having the perseverance to come back. I think that we've canceled or been interrupted a couple of times, so I appreciate the fact that you've returned and we've been able to have some discussion today. I want to ask you a couple of questions, first of all, on the CBC. Do you think it's important that Canadians have access to most of the information that the CBC possesses? And depending on how you answer that, can you provide examples of information that may not be appropriate for the CBC to release?
Yeah, well, I think that as the Information Commissioner had stated, and as concerns from this committee and in debates of Parliament have suggested, journalistic source, the privacy of journalistic source, of course, is important and should be protected. However, the CBC does receive public dollars, and unfortunately, it has used the exclusion under 68.1 by its own interpretation to use that as a blanket exclusion for blocking access to information requests that have nothing to do with journalistic source protection, and more so with administrative activities at the CBC. So I do think that there needs to be clarification within the Act, and I do think that this will provide it to bring the spirit of access to information as described by the Information Commissioner so eloquently just a few minutes ago, in line with how it is implemented.
Okay. Mr. Thomas?
We found it offensive that the CBC would go all the way to the Federal Court of Appeal in its disputes with the Information Commissioner in the past, and we were gratified when the Information Commissioner's position was upheld in the Federal Court of Canada and in the Federal Court of Appeal. But for us, the spectacle of taxpayers paying for the Information Commissioner's lawyers and the CBC's lawyers to have a dispute between agencies of the Government of Canada, we found that profoundly offensive. And so we welcome any attempt by a member of Parliament to put an end to this nonsense. And we herald Brent Rathgeber for his persistence in trying to improve the law to put an end to litigation, because I mean it is just a travesty that different agencies of all funded by the taxpayer would be going to federally funded courts to decide their differences. It makes no sense to us at all.
And further, if Parliament sees fit to release items that concern national security to an ad hoc committee, sworn in privy councillors on the spot to review Afghan detainee documents, I do have faith in the Information Commissioner, who is an officer of Parliament, to use her discretion and her professionalism in reviewing such information.
So, and then just further along those lines, do you, and I'm asking both of you here again, do you really feel that there needs to be a distinction between general information and the journalistic source, and do you firmly believe that the journalistic source needs to be protected, and do you think 461 does that? Or do you not think it needs to be protected?
I do think journalistic sources do need to be protected.
Okay.
I do think that Parliament is supreme in the land, and I do think that the Information Commissioner, instead of I've heard from other stakeholders that perhaps a judge would be more appropriate in reviewing such information, but the Information Commissioner, I do believe, is better placed within the supremacy of Parliament to review such information. And she stated earlier that she wouldn't be releasing this information. It would only be within the scope of investigation. And I do note that previous stakeholders at the CBC explained that when asked if any access to information requests had been made on journalistic sources, they did reply that zero, in fact, had been made. And I do think that any reasonable person would be able to see on the face what request constitutes information on the administrative capacities of the CBC versus the outing of a journalistic source, and I do know that any such information would be excluded as stated by the Information Commissioner in such a release, blacked out on those documents.
Okay. And do you agree with those statements, Mr. Thomas, or do you have a different view?
We believe that journalistic sources should be protected, and we've had some discussions with Mr. Rathgeber about it. We believe he's reflected and investigated the issue carefully, but I think it behooves the committee to get expert advice and to satisfy themselves with whatever amendments that come out of this committee that you know, journalistic sources are acknowledged by all sides to be protected. I realize that's a tough mandate to give you guys, but I'm sure you're up to it.
Okay,
Merci.
do I have some more time?
Non, plus.
No?
Plus de temps.
Okay.
You don't have any more time. Mr. Andrews, you now have the floor.
So, just for clarity, you disagree with the government amendment to raise it from a DM1 to a DM4?
Yes.
If the government is successful in getting that amendment passed, would you support this bill as amended?
We'll be very critical of this bill if it comes out with that. I mean, you're talking about people earning, there'll be fewer than 2,000 out of 212,000 in the core public service.
So would you support this bill if it was amended in that fashion?
No, we'll be very critical of it.
Okay. Mr. Taylor, Stephen Harper was president of the coalition.
Mm-hmm.
When was that?
That was prior to his entry into running for the Canadian Alliance. I can't recall the exact date, but it was for between 1 and 2 years. Yeah.
What would Stephen Harper have said of someone in the PMO giving a $90,000 check to a sitting parliamentarian?
I'm sorry?
What would Stephen Harper, as the president of this coalition, say about giving a $90,000 check to a sitting parliamentarian to cover up expenses?
I don't think that we have all the facts regarding what occurred, and I look forward to getting those facts before speculating on that issue.
What would Stephen Harper say as president of the coalition about accountability, and who would be accountable for those actions?
I think that Stephen Harper, well, I can't speak for Stephen Harper, but I do know that the National Citizens Coalition pushes the issue of accountability and transparency. It is very important to us, and if members of this committee want transparency and accountability, I think that they would support this legislation. I don't think transparency and accountability can really apply to the organizations or the institutions that are politically expedient for any one particular party. I think that with respect to the entire public service and the entire government, we should seek to apply accountability and transparency no matter how comfortable or uncomfortable it is, or how advantageous or disadvantageous it is for any one particular cause, because the cause of transparency and accountability is for the Canadian people and not for any one particular political party.
I can see that the members of...
Mr. Andrews, j'ai un rappel au règlement, M. Maître.
Point of order.
Bill C-461. This is not in order, and I don't think it's fair to the witnesses that they should be answering these questions. They came here to discuss 461. Let's stay on that topic.
Merci de votre intervention. J'étais pour rappeler qu'il fallait...
Thank you. I was just going to remind the members that to the greatest extent possible, we should be dealing with the Bill C-461 and also the spirit of the bill. So if Mr. Andrews wants to provide some context to his question on Bill C-461, I would like it if he did that to the greatest extent possible rather than go off in a direction that doesn't necessarily have a direct connection with the bill or the spirit of the bill. I will provide some flexibility to Mr. Andrews in order to be able to provide some context to his questions on Bill C-461.
Hope this doesn't come off my time. The witness did bring up the inquiry that's ongoing right now. He did talk about waste in the public sector, and he did talk about transparency, and he did talk about accountability of parliamentarians. And I can see how members opposite are getting very bothered by these type of questions, as you have pointed out. So I'll ask you another question. If Stephen Harper was president of the coalition, what would he say about a Senate whitewashing of a report?
Sir, if I can.
Bon, j'ai un point d'ordre, oui, monsieur.
Point of order, Mr. Workington.
You did give a very clear indication that there was a necessity to bring it to the legislation at hand. We have limited time with these witnesses, and I think it's important that we bring attention to the legislation that we're reviewing. I respect the fact that Mr. Andrews has he thinks he has a job to be entirely partisan in every opportunity possible. Unfortunately, the Canadian people deserve better.
Merci pour votre intervention. J'en profite pour rappeler à Monsieur.
Thank you. So I would just like to remind Mr. Andrews for one last time to please put his question in the context of Bill C-461. Otherwise, I'm afraid I'm going to have to move on to the next person on my list. So please try and provide some context to your question. I'm not going to tell you what question to ask, but I'm just going to say you can set the context so that we understand what the connection is with Bill C-461. I'll give you one last opportunity.
And I'd say to Mr. Workin, and I will take no advice for him on partisanship at this committee. Mr. Taylor, if Stephen Harper was president of the National Citizens Coalition, how would he account more accountability to this piece of legislation or to any other piece of legislation on being accountable to the people of Canada when someone in his office would do something that wouldn't be accountable?
I think if Stephen Harper were president of the National Citizens Coalition, he would appeal to all members present with respect to the current legislation before this committee to support that legislation if they do believe in accountability and transparency in all aspects of the public service.
Mr. Taylor, when Stephen Harper was president of the National Citizens Coalition, if a matter became before Parliament, wouldn't he be calling for more accountability and more openness and transparency like is in Bill C-461?
In fact, I sit before you today at this committee calling for more accountability and transparency in the public service and in government. And in the spirit of that, I encourage you to support this legislation.
I have no further questions.
Merci. Donc, je vais passer à Monsieur Workington.
Thank you. Then we'll now move on to Mr. Workington.
Moving back to the bill, I think it's important that we clearly search through this bill. And Mr. Thomas, I think when my colleague Ms. Davidson was speaking to you in the last little bit, you had talked about the necessity of getting the balance right. My constituents are taxpayers, and Canadian taxpayers subsidize CBC at a rate of $1 billion. I know somebody over there said that's not a lot of money. $1 billion where I come from is a lot of money. My constituents deserve to know. Now, there seems to be as I've reflected on the bill, as I reflect on access to information, Crown corporations, agencies of the federal government have been extended the responsibility to allow the access to information to the general population. There are a number of agencies and Crown corporations that deal with sensitive information. I think of BDC. I think of the individual bank loans that are being considered. That information has never been considered to be at risk because they are now subject to the Access to Information Act. You also look at organizations like Farm Credit who also lend money, same type of sensitive information. Nobody is charged that information somehow is now in jeopardy because it's subject to the Access to Information Act. There's all kinds of other departments, Immigration Department or Health Department that deals with very personal information of folks. Nobody has said that they somehow might be subject to disclosing personal information. So CBC now has undertaken a blanket exclusion and taken it probably to the nth degree to protect all kinds of information. The Information Commissioner has made it clear that at no time have they reviewed a request for journalistic source material. And so, my constituents are wondering, like, what's going on? Like, why is this the case? But my constituents also believe fundamentally in the necessity of protecting journalists and the sources that go to journalists. They believe in a free media. They believe that a free media is essential for a free society. And therefore, we have to get this balance right. And so I don't know if you have any reflections with regards to getting the balance right. It's important to us. Mr. Thomas, you had suggested that there may be a necessity for an amendment. We just heard from the Information Commissioner who's reluctant to see, she's reluctant to do anything different than this bill, but we heard CBC and other media organizations that were, pretty strong in their demand for changes. I don't know, have either of you got a reflection on how the balance might be assured?
Sure. I'll just say that it is very important to get that balance right. I do think that journalist source protection and the relationship between sources and journalists are important for a free media and a free society. I do think that the proposed amendment on the CBC regarding exclusion specifically for journalist source protection is a good one. I think that while providing an injury-based exemption for all other material, this is all good in principle. My only concern about that has been that the CBC has used pretty much any loophole in abusing that sort of trust that legislators and lawmakers have provided it for protecting information. I mean, I think I remember an example of an access to information request on how many cars the CBC has in its fleet. Right. And it was revealed that there was only one Ford 500 sedan in the entire fleet of the CBC after an access to information request was fulfilled. We'll just use that loosely. Many pages and pages and pages came back all blacked out. And indeed, after being pressed, I believe by the Information Commissioner, months later it came out that there were over 700 vehicles in the fleet. And this has nothing to do with journalistic source protection. This has everything to do with the daily administrative costs of the CBC, which is, in the interest of the taxpayers that fund it, for what Mr. Boulerice had described as a very reasonable amount, and as you have described as not really a modest chunk of change for taxpayers. So I do think that we need to strike the right balance. I do think that, yes, journalistic source protection is paramount, and that's why it's so critical that we get the balance right and do it here.
Now, you talk generally, I think both of you, about the desire to see a sunshine list in terms of pay. This bill doesn't call for that. It calls for something different. It calls for an ability to access information on individuals' pay through an access to information request. Tell me how that differs from the Sunshine List. You talked about the benefit in Ontario of a Sunshine List. I've heard reflections on that Sunshine List as being both positive and problematic. But this is different. This is different. Could you describe, I guess, the difference in your reflections on the differences between the Sunshine List versus what this bill calls for?
Sure. So this bill calls for case-by-case request for information on public servants earning DM or above, DM1 or above. The Ontario model puts all that information for every public servant that's earning $100,000 more on a public website. This is a great tool. Not many complaints. Taxpayers love this sort of thing. The problem with the current Ontario list, if I can just play advocate here on that, is that it's not available in a machine-readable format. For example, you cannot, in the discussion of open data and access to information and the ability to take data, to mash it up, to build programs that run through the data and be able to sort it. That's very difficult to do as the data stands on the public website, although it's disclosed. Ideally, what we would like to see is a sunshine list for all for all public servants earning $100,000 and above, disclosed on a website, but also available in a machine-readable format so that data analysts can process it easily.
It seems to me that, yeah, this bill doesn't call for what you're asking for.
Yeah.
But it may provide more usable information in terms of giving not only the pay but also a job description of the individual being requested to be disclosed. So that I think is different than the Ontario list. Mm-hmm. But of course, it doesn't allow for comparisons because it would be one person at another. Well, maybe there could be multiple people being asked for their pay as well as for
yeah. Part of the importance of this is to be able to compare the function of those in the public service versus their private sector. The related job or the related responsibilities and activities in the private sector, so that taxpayers can actually see if that level of compensation is competitive or if it's non-competitive.
Merci, Monsieur Workington. Le temps est écoulé.
Thank you, Mr. Workington. Your time is over. And that actually ends our meeting for today. We only have about 30 seconds left, so that doesn't allow time for any more questions. But I would just like to thank once again our witnesses for coming today. And I'd like to thank them for their contributions to the discussion on Bill C-461. I hope that it was helpful to committee members, and the meeting is now adjourned until next Monday.